U.S. Secretary of State Marco Rubio's July 13th threats to dismantle the International Criminal Court were dangerous. Dangerous not only because when the world's most powerful country declares war on the world's only international criminal court, it sends the message that the powerful are above the law and undermines access to justice across the globe, from Gaza and Iran to Sudan, Ukraine, and even here in the United States. They're dangerous also because of the implications on the constitutional rights for millions of American citizens. Rubio specifically calls out Americans advocating for justice, including Dawn. Executive Order 14203, which sets the framework for the International Criminal Court sanctions, empowers the Trump administration to jail Americans for up to 20 years and impose up to $1 million in fines for the very sort of activities that Marco Rubio calls out in his Wall Street Journal op-ed. If Rubio feels emboldened to call out Americans advocating for justice, what's to stop him from jailing them for 20 years on the very same basis? While ostensibly aimed at foreigners, the sanctions violate the fundamental rights of American citizens. The Trump administration is using the blunt instrument of sanctions not only to punish prosecutors, judges, leading Palestinian human rights groups Al-Haq, Al-Mizan, the Palestinian Center for Human Rights, and UN Special Rapporteur Francesca Albanese solely for seeking justice for mass atrocities, but also to police the political expression of millions of Americans, all to shield a foreign government committing mass atrocities. Other legal challenges to the ICC sanctions have poked holes in them or created carve-outs, but they have not addressed the restrictions on Americans advocating for justice on Palestine or working with the sanctioned human rights defenders. That's our focus. We are suing because U.S. organizations are self-censoring in all sorts of ways, just when their voice, informed by partners on the ground in Palestine, is most needed. As the genocide continues, as the apartheid deepens without the headlines, and just as the discourse in the United States is shifting in ways that create openings to advocate for justice and for an end to impunity and complicity. The sanctions at core are about ensuring impunity for Israeli crimes and U.S. complicity. Americans have the right to call for accountability without risking jail time. We seek an injunction to stop the Trump administration from enforcing sanctions to restrict Palestine advocacy. Marco Rubio, we will not let you dismantle the International Criminal Court or our constitutional rights. See you in court. With that, I'll return to my role as moderator and I'll pass it over to Joe.
Good morning, everybody. My name is Joe Pace. I'm a principal at J. Pace Law and counsel for plaintiffs. Today's lawsuit challenges the Trump administration's weaponization of U.S. sanctions law to criminalize peaceful advocacy designed to hold U.S. and Israel to account for committing grave international crimes. And to give you some context for this lawsuit, one of the Trump administration's first actions when it took office was to issue an executive order declaring a quote-unquote national emergency with respect to the ICC's investigation into alleged Israeli and American atrocity crimes. That order authorized sanctioning of any foreign person who supports those investigations, and the Trump administration started by sanctioning the ICC prosecutor, then it sanctioned the judges, all for simply doing the job the international community assigned them. And then it did something even more remarkable. It sanctioned UN expert Francesca Albanese and 3 highly regarded Palestinian NGOs for merely requesting that the ICC look into alleged US and Israeli atrocity crimes. These sanctions have had a profound chilling effect within the US NGO community. Once someone is added to the sanctions list by law, U.S. persons can't provide or receive any, quote, service from the sanctioned individual. And the term service is incredibly capacious. It could mean anything it confers a benefit on the recipient. This prohibition captures a wide swath of constitutionally protected speech. It prevents US citizens from making submissions in support of the ICC's prosecution. It bars them from coordinating their advocacy or exchanging information about Israeli human rights abuses with Albanese and the Palestinian NGOs. It subjects US citizens to potential prosecution if they do something as innocuous as organizing a training for the sanctioned entities on how to better conduct human rights investigations. And as we explain in today's complaint, this is a textbook infringement on the First Amendment. The Constitution does not permit the government to pick and choose what topics American citizens can discuss amongst themselves or with foreign parties. And if this administration is truly concerned that someone might persuade the ICC to bring a baseless prosecution against US and Israeli nationals, the remedy is not government censorship, it's government counterspeech. The US government has the largest microphone in the world, and it is perfectly capable of pleading its case directly to the ICC, assuming it has a case to make. What it cannot do under the law is silence US citizens who wish to express a different viewpoint. The lawsuit separately argues that the executive order runs afoul of IEEPA. That's the International Emergency Economic Powers Act, which is the law the president claims to derive his sanctions authority from. To trigger IEEPA powers, the president has to identify an actual national emergency. Now, the order says that the ICC investigations are a national emergency because they are, quote, baseless and illegitimate for two reasons, both of which are contrived. The first reason is that, according to the Trump administration, the ICC lacks jurisdiction over US and Israeli nationals because neither country has ratified the Rome Statute, which is the treaty that created the ICC. That's patently false. The Rome Statute explicitly confers jurisdiction over crimes that are committed within the territory of any country, including Palestine, that has consented to ICC jurisdiction. And that is not a legal fact that can be wished away by executive fiat in an executive order. The second false premise is that the US and Israel, and I quote, strictly adhere to the laws of war. This is a, let's say, quintessentially Trumpian exaggeration that is contradicted by the official assessments of both the State Department and the Department of Defense. And one need only crack open a newspaper to see a mountain of evidence that both countries have been violating the laws of war. And the sanctions violate IEEPA in an additional respect. Congress has enacted numerous laws clarifying that the president cannot use IEEPA powers to prevent US citizens from personally communicating with or exchanging information and ideas with people abroad, even if those communications qualify as a service to a sanctioned party. And this is because IEEPA was enacted to target real national security threats like terrorism and nuclear proliferation. It was not designed to muzzle peaceful advocacy or to cripple an international tribunal whose only job is securing justice for victims of the most heinous human rights abuses. And I want to conclude with one parting thought, which is this president's radical misuse of IEEPA should concern people of all political stripes. IEEPA now sits like a loaded gun that can be trained on any viewpoint that this or any future president finds objectionable. Today, that gun is trained on those who support ICC accountability efforts for US and Israeli crimes. But a future president could just as easily use this administration's playbook to declare a national emergency with respect to Israel's human rights abuses and sanction anybody who opposes efforts to prosecute Israeli nationals. And in so doing, bar Americans who support Israel from engaging their counterparts abroad. We are playing with fire here. And the president is setting an extraordinarily dangerous precedent with these sanctions. And so today we are asking the court to declare that the ICC sanctions are unlawful and that they cannot be enforced against American citizens who wish to engage in peaceful advocacy.
Thank you, Joe. Before I hand it over to Mike, just a note, if you have questions, you're welcome to put them in the Q&A function or to raise your hand at the conclusion of the speakers, or you can message me or my colleague Alex directly. With that, over to you.
Thank you, Omar and Joe. A little bit of background on why Don in particular filed this suit and how it has affected our activities. For nearly 5 years, Dawn has been submitting communications with evidence and legal analysis of alleged Israeli crimes, crimes of Israeli officials to the International Criminal Court. That's included Israeli military officials responsible for things like administrative detention, notoriously abusive units, military commanders involved in the early stages of the Gaza genocide. And our final one before the sanctions was a referral asking the prosecutor to investigate former President Biden and Secretaries Blinken and Austin for aiding and abetting the crimes for which the court had already indicted Israeli Prime Minister Netanyahu and Gallant. We had to stop that work in February of last year with the implementation of the sanctions out of fear of prosecution. We're still continuing our accountability work, but we've been cut off from the most natural venue for most of that, and that as we argue in our lawsuit, is an infringement on our constitutional rights for the reasons outlined by Joe before me. Not only did we have to halt our work with the ICC, we had to effectively end our relationships with the most prominent and respected Palestinian human rights organizations, namely Al-Haq, Al-Mizan, and the Palestinian Center for Human Rights, and UN Special Rapporteur Francesca Albanese. I want to emphasize that those sanctions on the Palestinian human rights groups and on Special Rapporteur Albanese make clear that the whole point of these sanctions was to silence Americans, was to silence anybody who's advocating for international justice, to ensure impunity for Israeli crimes, and to muzzle Palestine activism domestically here in the United States. A few notes that if we win, if we receive the injunction and the government is enjoined from enforcing these sanctions against Americans, we will immediately resume submitting work that we've done for other accountability mechanisms to the ICC. We will proudly stand and resume working with our Palestinian partner organizations and immediately resume our support of and submissions to Ms. Albanese. Just as importantly, as was alluded to by Omar and Joe before me, we hope and believe that a win would set a really important precedent and open the door for others in the movement for justice in Palestine here in the United States to do the same, to resume these activities, and to neutralize the chilling effect that this executive order and the abusive ways that the Trump administration has used it on free speech, on protected speech activities, and to show that we can have relationships with and work alongside our partners, as Joe said earlier, not just because the administration disagrees with their viewpoint or with ours. That is all for me for right now.
Thank you, Mike. Over to you, Anna Marie.
Hi, everybody, and thank you, Mike. My name is Anna Marie Stenberg. I'm a U.S. tax-paying citizen of Lebanese descent, lifelong human rights advocate and co-founder of Taxpayer Alliance Against Genocide, TAAG. TAAG is a grassroots organization of U.S. taxpayers who are committed to holding U.S. officials criminally accountable for their participation in and enabling the ongoing genocide in Palestine. Over the past 2.5 years, TAAG members have not stood idly by while U.S. officials used our tax dollars to carry out crimes against humanity in Palestine. This genocide couldn't be happening without the participation of the U.S. government officials using our tax dollars. TAAG members have tried everything within the U.S. to hold these officials accountable through legislative engagement, legal action, public campaigns, and direct appeals to government officials. These efforts have been met with silence or inaction. U.S. officials continue to operate with full impunity, and there is no genuine domestic proceeding that could or would hold these accountable for these international crimes. This must be stopped. We now turn to the ICC as the only international body that can investigate arrest and prosecute government officials for genocide and other crimes against humanity. For months, members of TAAG have gathered substantial evidence of the participation of U.S. officials, most notably Trump and Rubio, in the crime of genocide. For instance, U.S. has continued to supply Israel with 2,000-pound bombs made by General Dynamics here in the United States that are being used to level Gaza and kill untold numbers of children, men, women, mothers, fathers. Another example of the crime of genocide is that while Israel blocked all food, medicines, and humanitarian assistance from entering Gaza, the U.S. defunded UNRWA that had 400 distribution sites in Gaza, and the U.S. supported the Gaza Humanitarian Foundation, who had 4 distribution sites in Gaza during the starvation epidemic. By the end of May, it had been well documented that at least 400 Palestinians seeking food had been shot and killed at or near the GHF sites. Despite this, Secretary of State Rubio authorized $30 million in U.S. taxpayer funds to be sent to the GHF. The killings continued, and by September 2025, the United Nations had recorded a total of at least 2,319 people killed and their only crime was trying to obtain food and humanitarian assistance. We are prepared to submit that evidence and much more to the ICC Office of Prosecutor. We are blocked in doing so by the Trump executive order, and that is why we are proud to be co-defendants with Don and stand together today in filing this lawsuit. Personally, as a mother and a grandmother, that is something I must do. I cannot and will not be a bystander to genocide. We welcome others joining us in this effort to ensure that all Americans obey the law and do not commit genocide, crimes against humanity, or war crimes. Please join us at taxpayersalliance.net. Thank you.
Thank you, Anna Marie. And last but certainly not least, Tariq Raouf.
Yes. So over the last 3 years, 49 of my family members have been killed by American-made and funded weaponry. And now the United States is trying to avoid accountability by going against the International Criminal Court and anyone who dares to work with them. Just this week, Marco Rubio and the United States have doubled down on their attacks on the International Criminal Court, with Rubio writing a lengthy and pathetic opinion piece in the Wall Street Journal, explaining why the U.S. is choosing to dismantle the ICC. He claims that the court's actions against U.S. officials are illegitimate interventions that interfere with American military and law enforcement operations. And in a subsequent video released on Twitter, Rubio says if we stand idle, the U.S. will be at the mercy of foreign judges thousands of miles away, facing the constant risk of prosecution and even imprisonment for the so-called crime of defending their own country. But here's the thing. The word defense has been used to justify some of the most serious violations of international humanitarian law and acts of pure depravity, quite literally, for as long as this country has existed. It began with the idea of settlers coming to America defending themselves against people they called savages, as early American militias ransacked, pilfered, and decimated Native American villages in order to claim the very land our nation is built on. And today, this idea of self-defense is used to excuse the indefensible, the funding and arming of Israel's genocide in Palestine. The United Nations Commission of Inquiry has confirmed that Israel has deliberately and illegally targeted Palestinian children, with at least 20,179 children killed and 44,143 children injured since only October 7th. There's no defending such hostile and inhumane actions. The International Criminal Court is one of the only mechanisms the world has to even try and hold those responsible accountable for these crimes. The US wants to say that because they're not state party to the Rome Statute that founded the International Criminal Court, that the ICC has no jurisdiction. But like Joseph had mentioned earlier, Article 12.2a of the Rome Statute expressly authorizes the ICC to exercise jurisdiction over crimes committed on the territory of a state party, regardless of a perpetrator's nationality. Palestine is a state party, and any individual who provides the weapons and support those crimes made possible are participating in crimes committed on Palestinian territory. Therefore, the ICC has every right to hold the US and Israeli officials accountable for their crime. As Americans, we have every right to work with the international organizations and foreign nationals who are trying to use the ICC to seek justice, especially considering the fact that our own government has become so hostile towards anyone that dares to fight back here at home. It makes me think about the people who are trying to stop ICE from illegally kidnapping law-abiding individuals and how they are called terrorists and shot in the face. This kind of behavior from US officials at the international level is just another form of the same violence. We're standing at a crossroads, trying to prevent the US from committing more crimes the same way activists in the US are standing in front of ICE. And this attempt by Rubio is the US's attempt to shoot justice in the face, but we will not be deterred by such repugnant hubris. I refuse to sit by and watch as this government kills my cousins, my aunts, and uncles, and then try to worm their way out of accountability. One of my aunts was killed when she was at a Gaza Humanitarian Fund aid distribution site. She was trying to get flour to feed her family, and she was shot down like so many other hungry and displaced Palestinians who came to these places seeking help, only to find more death and destruction. If we sit back and allow the United States to try and dismantle one of the only mechanisms this world has for seeking justice, they will continue their tradition of defending themselves with more terrorism and violence. As American taxpayers, it is our duty to stand up and fight against the way our tax dollars are being used. No longer will we sit down as money from our paychecks is being used to kill children, while our own children are lacking the healthcare and education they deserve. Over the last 3 years, I'm happy to say that the number of Americans who have woken up to the lies of defense this nation keeps telling has skyrocketed. And I know that no matter what happens next, there is no turning back to the days where we believe this nation has ever defended anything other than its thirst for power.
Thank you, Tariq. We'll now move to the Q&A section of this discussion. So just a reminder, you can put questions in the chat. You can also raise your hand. I'll give folks a minute. We already have one question in the chat, so I'll start with that. But feel free to formulate your question, put it in the chat, raise your hand, or message me or Alex directly. So our first question comes from Connie. She asks, I thought the sanctions on Francesca Albanese were lifted. Is that not correct? I believe that's probably formed by something that was in Harrods today that I think was incorrectly, or let's say reported incompletely. So maybe I'll hand that question to Joe.
Yeah, so Francesca Albanese filed a lawsuit a few months ago challenging her designation. She got a favorable order in the district court. The district court ordered the designation to be lifted. And then the Court of Appeals stayed that order, so she's now back on the sanctions list.
Thanks, Joe. Any other speaker want to add anything? If not, we're open for other questions. I don't see any else in the chat, so if anyone wants to raise their hand, you're welcome to do so. I don't see any hands. We'll give it maybe another minute or two to see if folks have questions in the comments. Yes, there's another one that came into the chat. Muhammad Ali asks, when do you anticipate a decision? Joe, maybe I can also send this one to you. Maybe you can give folks a sense of what the timeline ahead is for what we.
Yeah, so we're going to be filing an application for a preliminary injunction, which is basically a procedure to get expedited relief. That's going to happen over the next few days. Typically, those rulings happen very quickly. I would imagine we'll have an answer on the preliminary injunction application in the next 2 months. And then after that, It's hard to tell. It could be appealed. If the government doesn't appeal, then there's a lot more legal wrangling that has to happen before it becomes a final order. But the bottom line is we're going to get some indication as to how the judge views this lawsuit, probably by the end of September or October.
Thank you. I think we can leave it there. That's a straightforward answer. So the next question that we received is, was the ICC not designed for the specific purpose of not pursuing Western powers? Is it not playing out on the exact same way it was intended? I can start to take this and I can invite others to come in. The creation of the International Criminal Court was part of a decades-long quest by advocates from around the world to have a venue for the world's worst atrocity crimes to be heard. And actually, of course, there was much back and forth in the design of the Rome Statute of the International Criminal Court. But I don't think it's accurate to say that it was designed to give Western powers an out. Yes, the court was rooted in the principle of consent, right? So ultimately, the primary basis by which the court exercises jurisdiction is when states consent to the application of the Rome Statute to all crimes committed within that territory. And indeed, there are 125 state parties to the International Criminal Court. I think what's critical here about the mischaracterization by Marco Rubio and the US administration is that while states can consent to the exercise of jurisdiction within their boundaries, they don't get a get out of jail free card when it comes to crimes committed in areas in which the ICC exercises jurisdiction. The court has jurisdiction in that territory regarding crimes committed by all rights abusers. So just as Western states encourage the International Criminal Court to investigate Russian crimes committed in the Ukraine, the very same principle would cover crimes committed by the United States in Afghanistan or committed by the Israeli government in the West Bank and the Gaza Strip. So certainly, there are discussions about where the court has focused its investigations. But the reality here is, in design, it was meant to be a global court that filled a critical gap, for the worst crimes. And it's also based on the principle of complementarity. So any government can investigate crimes instead of, and if they do so in a credible way, the International Criminal Court would lack jurisdiction. But we're talking about situations like in Palestine, where there's endemic impunity for really grave abuses that have taken place. Certainly the United States and other powerful states want impunity. They don't want to be held accountable. That's at the root of the US response, but that's not what the court was designed to do. Does anyone else want to come in on that question?
And Palestine asked specifically for ICC intervention, and that's what happened.
That's correct. Palestine in January 2015 did indeed consent to the Rome Statute's application. And the International Criminal Court has, of course, issued arrest warrants against Israel's sitting Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant. Okay, let me move on to the next question. I don't see any other speaker that wants to come in on that. So the next question is, how can people support this cause? So does someone want to take that? I can if not. I'll start with that. Certainly, we think this lawsuit is a really important one. The reason we're filing is we've seen significant degrees of self-censorship when it comes to U.S. advocates for Palestinian rights. And so we think it's really important to spread the word about this case. We think the implications will be broader than just to Dawn or to Taxpayers Alliance Against Genocide. So we really encourage you to spread the word. There certainly will be opportunities ahead, and Joe, you're welcome to say more, for individuals who are interested to submit amicus briefs. There will be opportunities to also share the word, attend possible hearings, in this case in New York down the road. I will also note, of course, that both Dawn, I'll leave it to Taxpayers Alliance Against Genocide to speak about that. Certainly, we are interested in folks that might want to support this case. So if you're interested in financially supporting our ability to continue moving this case forward, please welcome to reach out to me about that. And I don't know, Anna Marie, if you want to come in on the TAAG side of this as well.
Yes, TAAG is building a grassroots movement, and we urge you to join us and donate if you can. Our website is www.taxpayeralliance.net. Thank you.
And donations are also possible on Dawn's website, and please do specify it's for this particular effort. Okay, next question in the chat. And again, reminding people, you can raise your hand. I don't see hands raised. So Alex, let me know if I'm missing hands raised. Just making sure I'm not in the, okay, I am not. So let me move forward. What risks will the plaintiffs face? What is the possible retaliation from the Trump administration? Joe, is that one you can take?
Yeah. I don't think there's anything the Trump administration can do legally to retaliate against Dawn or TAAG for bringing this lawsuit. And I mean, in fact, if the administration did retaliate, it would only help our lawsuit because it would underscore the fact that the administration is attempting to punish organizations from engaging in protected speech. So I think it would be a monumentally stupid thing for the administration to do. But I put nothing past this administration.
And we're prepared. We're prepared. We're willing to take any risk we have to in order to stop this genocide.
Anyone else want to add a comment there? Okay, next question I see in the chat. In general, lawsuits aside, would the Trump executive order be something an incoming Democratic administration 2029 would overturn, or is anti-ICC sentiment largely bipartisan? Mike, do you want to take this one?
Sure. I mean, we have the answer to that already, sort of in the history books, which is that Trump issued a similar order in his first administration, and that was rescinded by President Biden when he took office. Not necessarily because he supported the ICC, but I think he saw some of the same reasons why this was an inappropriate response. I'm not going to say similar to, but like we have in our lawsuit. That said, I think that this lawsuit is doing something even more important than that. Because as Joseph mentioned, you know, the powers that the administration is invoking in its use and application of these sanctions could be abused by any administration, whether it's toward the ICC or any other issue that they, you know, summarily declare in an executive order to be a national emergency. We've seen this used for legitimate purposes. We've seen it used for illegitimate purposes like this, and we've seen it go back and forth between administrations. The two prime examples of the past few years are Trump issuing the ICC executive order in his first term, Biden revoking it, and Trump reinstating it or reissuing a new one in this term, and the inverse, if you'll call it, is the Biden administration's sanctions against violent Israeli settlers, which the Trump administration revoked on the first day. Now, sanctions are inherently not a tool that involves due process. They're an extraordinarily blunt tool. They're one meant for actual national emergencies. We see them used against terrorists, against drug cartels, oil smugglers, all sorts of things that it's harder for the U.S. justice system to actually contend with directly, and where they try and use them as a tool of coercive diplomacy. Using them in ways that restrict American speech is what we believe is the truly abusive part here, and the part that it's crucially important to get the courts on the record saying that it's not permissible for future administrations or for this one to use in ways that stifle and hamper Americans' constitutionally protected rights.
Thanks, Mike. Any other speaker want to come in on that question? Okay, I think I've gone through all the questions in the chat. I'm going to give it another minute to see if anyone wants to raise their hand or has another question for the chat. Okay, I see one more entering the chat now. Will the Geneva Convention be an argument? Joe, over to you.
Probably not. I don't think that's going to figure into our legal arguments.
I can just add to that saying that the Geneva Conventions and international humanitarian and criminal law are the subject of what we were being prohibited from engaging with by these sanctions, and what we would like to resume engaging with, primarily with the ICC. But there's nothing directly about international humanitarian law and the Geneva Conventions in our application against the government, against the U.S. government, in this case.
Great. Any other responses from the panelists? Okay. I think we went through the questions in the chat. I'll give another minute for any last Q&A questions. I will just note while people do that you're welcome to reach out to any of us. The press release includes contacts. You can reach out to Dawn through any of us. Maybe we'll include in the chat an email address if you would like to set up interviews or you would like additional materials. TAAG can also put in the chat a contact email for them, and Joe can do the same, so that if you have any additional questions. I will give it one last minute, otherwise we can conclude. I don't see any other questions, so maybe we'll leave it there. Thank you, everybody, for joining us. We will continue to update folks on this lawsuit. If you're not signed up to Dawn or TAAG's email lists, please do reach out to both groups. Again, we'll provide some contact information in the chat, and thank you all for joining us. Bye-bye.
Thank you all.
Thank you.